Ladies and gentlemen, we are ready to start. So welcome to all of you, those who are in presence and those who are connected. We are starting the event for the launch of the UNIDROIT IFAD Legal Guide on Agricultural Land Investment Contracts. I'll now give the floor to the representatives of the two cooperating organizations, starting from Ms. Catherine Megan, General Counsel of IFAD. Megan, you have the floor.
Thank you so much, dear Madam President. And I also really want to welcome Mr. Secretary General, all of the wonderful UNIDROIT colleagues with whom we've worked over the years on the launch of this exciting guide. And of course, the members of the Governing Council and our esteemed experts here to talk about this with us today. It's truly a pleasure and an honor to be here today to launch this wonderful guide. It's been lots of time in the making, lots of thought and experience have gone into it. And I'm just delighted with how beautiful it looks and how clever it is inside. This is a handy but impactful guide. And that's really what I wanted to talk about just very briefly today in my opening remarks. First, to say what an honor it is for IFAD, the International Fund of Agricultural Development, of which I'm the General Counsel, to work so closely, not just on this guide, but over decades with UNIDROIT on our important missions, and to have these missions work together to help those whom we serve. And for IFAD, that is the rural poor, as we look to assist those who really live in the last mile of the developing world to build resilient rural agricultural communities. We want to make sure that those who feed us can feed themselves. And the mission of IFAD aligns so well with the work of UNIDROIT in creating this guide. I'd like to highlight that, we've been working together for many years on agricultural aspects and private law themes with very satisfying results. And I think that this guide does more than perhaps what it just looks like in this booklet. We do look at financing together as well as working technically on guides like this. And this certainly supports legal security in the agricultural sector. But it also has, I think, some aspects that as international organizations, this is something that Ignacio and I have spoken about. It's very important, I think, to use our roles and our convening power in these situations to have a look at private law and agriculture with a lens, given our United Nations kind of background and history. And so in particular, we have tried to focus on issues in this guide, including environmental law, the rights of Indigenous people, gender equality, and other issues about which we are all, I think, here today very passionate, but might perhaps not be included with this type of focus in a similar guide written by commercial lawyers. And I can say this because I was a commercial lawyer for many years, so I hope that's okay. So I'm very proud to be here today to help co-launch this guide with my wonderful UNIDROIT colleagues. And I'd like to just highlight in closing, I think, a huge congratulations to UNIDROIT on its century. It's not many organizations who have been around, for a century and continue to produce high caliber, thoughtful, legally insightful and impactful work that really changes the lives of people on the ground. And I can say that I personally look forward to working with you very closely, perhaps not in the coming century. I don't know if I'll be that old, but at least in the next decade or so as we start together the coming century and what I know is going to be a long and continued noble history for this wonderful institution of UNIDROIT. Thank you.
Thanks a lot, Kathy. And now I move to the other organizations, to Secretary General of UNIDROIT, Ignacio Tirado, please.
Thank you, Madam Chair. Thank you, Katie, so much for your kind words. You epitomize very well the best of one of the best organizations in the world of food security, which is so important. And we are so proud and so happy to be able to share with you the work in this guide and in previous guides. IFAD is an absolute key player in development of the food security and the area of agrobusiness. And you honor us with your presence, with your collaboration, and with your commitment for future work as well. So thank you so much. I'd say a few words about the project. The project follows suit from previous experiences of the three organizations, because the FAO has also participated substantially in the process leading to this moment. The previous guide, the legal guide on contract farming, which is an extremely successful instrument. We are sure that this instrument is also going to be extremely successful. Comes, if you'll allow me and indulge me for a minute, comes from a long time. And we're fortunate enough to have here my predecessor, the Secretary General before me, Angelo Estrella Faria, who, under whose tenure this project was started. Thank you, Angelo, and congratulations also for the part that's yours. I'd like to make, if you will also indulge me, reference to the previous legal officers that worked here. I can't forget to mention Neil Bergman, who worked so hard in this instrument for a good number of years. And of course, the current legal officers that did the work, Carlo Di Nicola and especially Priscilla. With Brazilian people, I always struggle to know how many of the last names I need to pronounce. Pereira de Andrade is only the last name, I usually say all of them. So Priscilla and Carlo, thank you so much. And well, this is of course, I can't forget the chair of the working group, Professor Jose Moreno, who is a member of our governing council, who is here, who also did a fantastic job with his characteristic excellent left hand, as we say in Spanish. He firm leadership with kind words, which is a very important thing always. This is not an ordinary instrument, because this is not an easy topic. Investment contracts for the use of land are politically a controversial thing, but they do happen in real life. And because they do happen in real life, it is of the essence that the three organizations and a group of experts come together and make sure they produce a guide which guides this type of investments through the right path, that all the rights of the rightful tenure holders, the right values are respected. So this is precisely what this does. Acknowledging that this type of transactions exist, it gives guidance to ensure that these transactions occur in the rightful manner and are not only profitable for the community from a business standpoint and make the country grow and thrive, but also from a social standpoint, which is very important. So there is a lot of private law here, and there is a lot of justice here. And this is, I think, very important. I think it is important that I highlight that this book, this legal guide, is the result not only of many years of hard work, but also the result of an unprecedented public consultation. This was shared in an extremely widely manner to ensure that we got the entire input of the everyone concerned in civil society with this type of transactions. So, for example, first of all, and this is another occasion in which we can highlight the importance of our collaboration. We benefited from a grant from IFAD to be able to consult internationally on the content of this guide. We held three different consultations in three different continents, one in Nairobi, one in Sao Paulo, and one in Beijing. They were very successful, and we got a lot of very useful feedback. The initial draft was shared online for months, and it was even shared through some of the most important platforms in the world in the sector. And I'd like to quote, for example, the Global Forum on Food Security and Nutrition, the FSM Forum, hosted by FAO, the landportal.org or Afronomics, just to mention some of them. The content of the guide was also discussed at some of the main venues in the world, at the World Bank, at the Committee on World Food Security plenary sessions. It was also discussed at the International Bar Association. So more discussion than this is not possible. And this is the result of all that input, because all that input was received, processed, and a drafting committee was formed with IFAD, FAO, with the experts, and the guide was fine-tuned to ensure that the adequate feedback from civil society was incorporated. So this is fine work of detail, how, and this is how good legal instruments need to be drafted with time, slowly cooked with low fire, and we are persuaded this is going to be a very useful guide going forward. So thank you again, Katie, and to everyone who participated in this. And over back to you, Madam President.
Thank you, Ignacio. So now I think it's time to go to the overview of the preparation process and the structure of the guide of ALIC. I'll now give the floor to the chair of the ALIC working group, this Professor Jose Antonio Moreno Rodriguez, who's also member of the governing council of UNIDROIT.
Thank you very much, Madam President. I am pleased to introduce the UNIDROIT IFAD Legal Guide on Agricultural Land and Investment Contracts, the ALIC Guide. As a member, here it is. As a member of the UNIDROIT Governing Council, it was my honor to chair the working group established in 2017, comprising of 15 internationally recognized legal scholars, practicing lawyers, and representatives of international organizations. In addition to the, beyond the experts involved, more than 15 representatives of non-governmental organizations, agribusinesses, and other stakeholders attended the working group sessions as observers. The experts and observers were specialized in the areas of private and public international law, as well as in investment law, environmental law, and in agricultural development issues more broadly. The working group also reflected a broad diversity in terms of geography, gender, and legal traditions. This group met 4 times in Rome and twice virtually in a 3-year process. All meeting reports, including summaries of the working group's deliberations and lists of participants, are available in the UNIDROIT's website. The UNIDROIT Secretariat had an essential role in the drafting and revision of the document together with IFAD and highly qualified experts. In addition, the drafting process was inclusive and transparent, with the UNIDROIT Secretariat together with IFAD and members of the working group participating in various conferences and events to raise awareness about the guide and to seek stakeholder input, such as in the World Bank's annual Land and Poverty Conference and in plenary sessions of the Committee on World Food Security. The guide attempts to introduce clarity and guidance regarding investment contracts entered by governments and local communities with investors. The guide encourages alternative models of agricultural investments which do not involve large-scale leasing agreements. Several issues related to these agreements have proven problematic in practice, and the guide expects to advance the essential contribution for the betterment of said relationships. The legal discussion and analysis throughout the guide follows a concrete approach based upon contract principles and practices, actual investment operations, and input from a broad range of experts in areas such as contract law, land tenure, responsible agricultural investment, human rights, and environmental protection. The guide also addresses grievance and dispute resolution mechanisms, including arbitration. As a legal guide on contract farming, the ALIC legal guide builds upon the UNIDROIT principles of international commercial contracts, UPIC. As the Deputy Secretary General, Professor Ana Veneciano will further explain her remarks. I want to also thank the collaboration of FAO and now pass the word to its representative, Donata Rugarabamo. Thank you very much. It's really an honor to present this outstanding contribution. Thank you very much, IFAD. Thank you very much, UNIDROIT.
Thank you, Professor Moreno. So now the intervention of the General Counsel of FAO, Donata Rugarabamo, was already announced. So please, Donata, you have the floor.
Thank you very much. And I thank you all in particular for the opportunity to be able to speak with you briefly today. I wanted to be able to attend the launch because of the importance that FAO vests in its collaboration with both UNIDROIT and IFAD, and indeed to outline in this segment of the launch the technical expertise that we felt we brought and lended to this process. And therefore, I requested the opportunity to be able to intervene in this context in the discussion on the preparation of the guide. As many of you know, FAO has collaborated closely with UNIDROIT's workstream on agricultural matters. As was earlier mentioned by the Secretary General, we've worked very, very closely on the contract farming legal guide, and we continue to work on other aspects. And this collaboration, including as well the collaboration at IFAD, we feel very much shows the value of joining FAO's technical experience and public law background with your private law experience in UNIDROIT. And so, as a consequence, as soon as the governing body of UNIDROIT decided to proceed with the legal guide on agricultural land investment contracts, we decided that we would lend our technical and legal support to the process. Therefore, members of FAO's Development Law Service, as well as the teams working on the voluntary guidelines on responsible governance of tenure, land, fisheries, and forestries in the context of national food security, the VGGT, and the team which was working on the principles of responsible investment in agriculture and food systems, CFS-RAI, all participated in this work. In addition, FAO representatives in China, Kenya, and Brazil also participated actively in different parts of the process. As noted already by the Secretary General, there had been these consultations held in these 3 different countries. From a technical perspective, we consider that the guide is fully consistent with the VGGT and the CFS-RAI, as well as consistent with relevant technical FAO guidance. We very much commend UNIDROIT for the very extensive consultative process, as was noted by, indeed, the chairperson of the working group. And truly, you are to be commended for having done such wide-reaching and such deep consultations to reach such a satisfactory outcome. In conclusion, I would like to just say that FAO is very happy to have such good working relationships with UNIDROIT and IFAD, and we look forward to continuing our collaboration on the next project addressing agricultural investments. Thank you very much for this opportunity. I hand back to you.
Thank you, Donata. Now I do give the floor to okay, sorry. So now Priscilla. Yeah, exactly, because I saw some movement, sorry. So now it's Anna Veneziano was also mentioned by our chair of the ALIC working group. Anna Veneziano, Professor Veneziano is our Deputy Secretary General. Anna.
Thank you very much, Madam President, and I too would like to congratulate IFAD and also my own organization, if I may, and my colleagues who worked on this very important project. What I would like to do is very briefly start with the first of the instruments that were elaborated together with the FAO and IFAD, the Contract Farming Legal Guide, and see what is the relationship between these 2 instruments, the first and the second, in terms of what we have learned the learning process in developing the contract farming guide. And so that's why I would like to focus on 4 main points. The first was already mentioned by previous speakers, and particularly the Secretary General of UNIDROIT, the process. So in the 2 situations, we had a working group with participation of the partner organizations, but also the international experts and representatives of stakeholders from the start. We also had a very wide consultation process, both with events in person and online. And actually, as the Secretary General said, for the ALIC guide, it was even broader and unprecedented. And we had also consultations with governments and other sectors of society. Then there is a second point, which is the premise, and this was also already anticipated by the Secretary General and by the General Council of IFAD. These instruments have an important role because they recognize the existence of certain practices and they want to steer them. They would like to offer guidance to help building balanced relationships, taking into account the interest of the various parties involved. A third point is the centrality of the contract, the importance of private law in a way, because through the contract you can reach a number of policy goals. And this is also what explains the structure of the 2 instruments. And I think Priscilla will go more into the detail of the structure of the ALIC guide, but the idea is to follow the life of the contract from the beginning to possible dispute resolutions and to connect this with the regulatory framework, creating a sort of awareness and bridge between the 2. And that's why the cooperation with the other 2 organizations was so important. And that was, again, unprecedented and even stronger in the context of the ALIC guide, where these elements are particularly important. And so, just to conclude, this kind of instrument is a legal instrument, and it's a bridge between the general principles that already exist at international level and we would like to implement, and what happens in practice, the contracts, legislation. And it's an important bridge because it gives the opportunity to governments and to parties to have a more detailed guidance on how to do these things. Of course, they are general instruments, so there will be a path forward in the implementation. And therefore, this is a full stop in a way of an activity, but the beginning of another. And so thank you very much. And congratulations again.
Thank you, Anna. And now it is the time for Priscilla Pereira de Andrade, for introducing the structure and the content of the guide, please.
Thank you very much, Madam President. It is a pleasure to be here today to introduce this legal guide in the presence of General Counsel from IFAD and the Secretary General from UNIDROIT. As just explained by the Deputy Secretary General, Professor Anna Veneziano, the ALIC guide, the Agricultural Land and Investment Contracts Guide, broadly follows a very similar structure as the legal guide on contract farming. It seeks to provide concise and innovative legal guidance that operationalizes a number of key instruments, key international instruments, among which the UN Guiding Principles on Business and Human Rights, the VGGT, and the CFS-RAI. The ALIC guide has 7 chapters and a checklist of issues at the end, which may be very useful to put in practice. If you look at the structure of the ALIC guide, at chapter 1 starts with the legal framework. So this chapter seeks to assist with the evaluation of the applicable legal framework including both domestic and international sources of law. Chapter 2 addresses the parties and the contractual arrangements. So Chapter 2 examines who are the potential contracting parties and who are the other stakeholders that may be interested in this operation. This same chapter, Chapter 2, describes some of the contractual arrangements that these parties may decide to adopt. Chapter 3, the third chapter of the guide, presents the key elements of the pre-contractual negotiation process. So it is a very important chapter in the sense that it brings guidance in terms of due diligence, feasibility studies that have to be prepared, business plans, and it also brings guidance in terms of impact assessments and impact assessments of several types of impact assessments. So not only social and environmental impact assessments, but it also gives guidance on human rights, human right-based impact assessment, which is quite a new approach. Chapter 4 of the guide addresses the rights and obligations of the parties. And this chapter aims to assist not only with the negotiation of the clauses and provisions to be included in the contract, but it provides notions and ideas of safeguards that have to be included in the guide related to land tenure, human and social rights, including food security, water rights. It considers the need to empower youth and include adopt a gender perspective. And it also highlights guidance in terms of environmental protection. Chapter 5 of the guide, as Professor Ana Veneziano was mentioning, we considered the life cycle of the contracting process. So Chapter 5 deals with how you manage the contractual relationship. How do you deal with cases of non-performance, and what are the remedies that are available if needed? So Chapter 5 presents the ideas of the types of risks that may appear in a particular investment in land, and it seeks to present instruments that promote cooperation between the parties and the stakeholders. The legal guidance analyzes possible excuses and remedies for non-performance. So it's very similar to what was done in the contract farming, but adapted to this specific land investment case and all the stakeholders and third parties that may be involved. Chapter 6, transfer of rights and obligations under the contract and return of tenure rights. This is a very interesting and important chapter in the sense that even if land leases tend to occur in a long term, this chapter highlights the importance of considering what needs to be done with the agricultural land when the investment finishes. So it brings guidance in terms of how you compensate if necessary, what are the types of contractual transfers that need to be included to the public government and to the communities involved. Afterwards, the last chapter, Chapter 7, addresses grievance mechanisms and dispute resolution mechanisms. So it presents the types of grievance mechanisms and disputes that commonly arise, that may arise in the case of land investment. And what is interesting about this chapter is that it brings examples of grievance mechanisms, not only judicial mechanism, but it also gives guidance on the possibility of using non-judicial grievance mechanisms. So in the event that if a dispute arises, the guidance will give a checklist of stages that may be considered before going to courts and eventually seeking to solve the dispute, the eventual dispute, in a cooperative way. So it is much connected to the chapter on remedies that I mentioned before. Considering the time limit that I have, and considering that many of these experts that were invited to present during this launch today, and knowing that they will address in more detail some of the topics that are presented in the guide, I would like to take a few moments to thank all the UNIDROIT Secretariat, especially in particular the Secretary General and my colleague Carlo Di Nicola, for the wonderful teamwork in reviewing and finalizing this high quality guide. I'm also very thankful to the feedback received from other colleagues within the Secretariat, as Professor Anna Veneziano, Marina Schneider, Feline Welling. And we could not forget to mention all the work that was put into this guide for its finalization, and the process contribution of some of the UNIDROIT secretaries, particularly Isabelle Dubois and Françoise Jean. I would also like to take a brief moment to highlight once again that this guide began in 2016 under the leadership of the former Secretary General José Ângelo Estrela Faria, which is in the room with us today, and we're very grateful for his presence. Most of the work in the development of the ALIC 0 draft was led by the former senior legal officer, as mentioned previously by the Secretary General in his opening remarks, Neil Bergman, and also the former principal legal officer, Frédéric Mestre. So this guide owes a lot to their work and to their admirable leadership. Without further ado, I would like to pass the floor to my colleague, Carlo Di Nicola, which will be moderating the next session, which will certainly give much more feedback and much more detailed information about the topics that I briefly highlighted that are presented in the 7 chapters of the guide. So I really hope that this guide is useful for you all, and that we have the opportunity to work together in its implementation. Thank you. Thank you for the attention.
Thank you very much, Priscilla. Indeed, we are very fortunate today to have a number of the experts who are on the working group and observers, as well as external observers who participated in the consultation process that led to the creation, the drafting, and then the finalization of the guide. So I'll just take 2 minutes to say a few words personally, and then we'll proceed with our excellent, outstanding group of experts. I'd like to also echo the words of my colleague Priscilla and thank all the colleagues within the Secretariat, our counterparts at IFAD, FAO, and all of the experts on the working group, the observers, as well as the many people. We received comments, hundreds of comments throughout the online consultation, through the 3 regional consultation events. And it was very enlightening to go through when so many people go through a piece of writing, a piece of work you've been doing, and they go through it with a fine-tooth comb. It provides a very interesting perspective on all the different lenses through which one can look at a piece of legal work. So it was quite an enlightening process. And so thank you, Priscilla, for all the collaboration and the long hours working on finalizing the draft. And then finally, on a personal note, I'd just like to echo the comments made by the General Counsel of IFAD and the Secretary General Ignacio Tirado, to say that indeed this is a very, very important piece of work. It's not an easy task, bridging the private law world with the larger themes involved in international development in the agricultural area. And on a personal note, I'd just like to say that as someone who, previous to coming to UNIDROIT Secretariat, I worked as a lawyer at FAO's legal office and the World Food Program of the United Nations' legal office. Certainly no one who's done that kind of work, who's been exposed to those kinds of very serious development challenges, no one can come away from that not being quite sensitive to the real challenges out in the world in terms of trying to help people feed themselves rather than continuously being dependent on external aid. So this is an important tool, and we're very much looking forward to being able to disseminate and share and see the final product take wings. So with that, with those few personal comments, I'd like to invite our first speaker today, our first expert. We have Professor Pierre-Etienne Kenfack. He's a professor of law at the University of Yaoundé 2. Pierre-Etienne, est-ce que vous êtes en ligne? And we'll give the floor to you for 10 minutes.
En ligne, merci. I first apologize if the connection is not very good from Yaoundé. Can you hear me, Mr. Nicolas, please?
We can hear you, thank you. On vous entend.
Thank you so much. Merci beaucoup. Thank you, Mr. Nicolas, Mr. Moderator, for giving me the floor. Good afternoon, Secretary General of UNIDROIT, General Counsel of IFAD, fellow experts, ladies and gentlemen. As you know, it is a great emotion for me to take the floor on the launch of this important project which we have been working on for several years. I would like to be
Pierre-Etienne, est-ce que vous êtes toujours là? Perhaps we can, while we're looking into the connection, we could invite the next speaker.
Maybe ask the speaker to turn their video off. That might help.
Okay. Pierre-Etienne, est-ce que vous entendez? Okay, maybe we'll write to him. And then, so I will ask our next speaker while we look into the connection. Julia, are you there?
I am. Good afternoon.
Yeah, so Julia, we'll ask you to go now, and then we'll try and get Pierre-Etienne back on after your intervention. So I'll just quickly say Julia Panfield is Director of New America's Future Land and Housing Program. Julia was one of our experts on the working group. So Julia, please, you have the floor. Over to you.
Fantastic. Thank you very much. And good afternoon, Secretary General of UNIDROIT, General Counsel of IFAD, fellow experts, ladies and gentlemen. I am so grateful to see this guide, which was several years in the making, out in the world. And in particular, in addition to those who have been thanked already, I'd like to really thank two former members of the Secretariat whose efforts were instrumental in making this guide what it is, Neil Bergman and Frédéric Mestre. I know that Professor Kenfack was planning to speak a bit about the concept of legitimate tenure rights holders and the innovation of this guide in including not just legal tenure rights holders, but also legitimate tenure rights holders in the investment contract. And I was planning to speak about the ways in which we could do so. So, leaving space for Professor Kenfack to really lead that discussion, I'll just quickly say that legitimate tenure rights holders are individuals and communities who live on, work on, or otherwise occupy the land being transacted, and whose rights and claims are considered socially legitimate, but they may not have legal right to the land in question. And this often causes complications during the investment. I will leave space for Professor Kenfack to really explain this. And I see him back on the screen. Should we try once more, or is it preferable for me to provide my remarks and then to come back to Professor Kenfack?
Julia, please continue, and we'll let you wrap up, and then we can go back to Professor Kenfack. Sure. Thank you so much.
Sure. On the slide deck, we can move to the next slide. What what we have seen is that when these types of large agricultural investments go poorly, it's often because the rights and the wishes of local communities, one back please, the rights and wishes of local communities who have legitimate claim to the land but often lack the formal documentation have been violated. So how do we ensure that the rights and wishes of legitimate tenure rights holders are respected? The most direct way is to include them formally in the transaction. The guide discusses 3 ways of how to do this. First, the legitimate tenure rights holders can be party to the contract itself. This is usually through a multi-party contract. The way I've seen this most often is that the contract has 3 parties. First, the company or the purchaser of the land. Second, the grantor of the land, that's usually the government. And third, either the individual legitimate tenure rights holders listed out or some sort of a community association or other vehicle that represents the legitimate tenure rights holders together. The second way to include these parties in the transaction is to make them party to a separate agreement, such as a community development agreement that's linked to the investment contract. And third, legitimate tenure rights holders can be third-party beneficiaries of the investment contract. So contracts in which legitimate tenure rights holders qualify as third-party beneficiaries will confer certain rights upon these holders and provide them access to remedy in the event that those rights are violated. Next slide, please. So I'll just spend a minute digging into how these different contractual arrangements could work. And I'll just note that this is really a rapidly evolving area of practice. So there is no standard right now, which I think is also a reason why the release of this guide is so exciting, because it provides a bit of guidance and guardrails in a relatively new practice. So a bilateral contract between the investor and the grantor is pretty straightforward. I won't spend time on it. That's the typical contract we continue to see in these investments. But a multi-party contract becomes more interesting. And as I mentioned earlier, we're already seeing some experimentation with tripartite contracts, which typically contain rights and obligation sections for the investor, the grantor, so that's the legal tenure rights holder, and the legitimate tenure rights holder, respectively. And for the legitimate tenure rights holder, the rights within the contract might include, for example, continued access to the land and resources in the concession area, so long as that access doesn't interfere with the activities of the investment. But I also want to be clear that if a legitimate tenure rights holder is a party to the contract, they'll also have obligations. And those obligations could include, for example, non-interference or similar covenants aimed at ensuring cooperation between the legitimate tenure rights holder and the investor. And finally, the investment contract itself may be only between the investor and the land grantor, but the contract may explicitly reference a related agreement, which does include the legitimate tenure rights holder. So most often we've seen this be a community development agreement. The CDA will stipulate the rights and the obligations of the investor vis-a-vis the legitimate tenure rights holder. And in particular, it might stipulate the economic and social benefits that the legitimate tenure rights holder will get in exchange for access to the land and resources for which they have rights and for other community support of the investment. Next slide, please. Finally, legitimate tenure rights holders can be third-party beneficiaries of the investment contract. And one of our co-drafters, Professor James Gatti, has conducted significant research on this topic. In general, contracts can confer rights upon third parties who are not signatories to the contract, but stand to benefit if the contract is fulfilled. And these parties are called third-party beneficiaries. The voluntary guidelines and the CFS RIDE principles recognize that investors are responsible for respecting the legitimate tenure rights holders in the context of an agricultural investment. And the UN guiding principles on business and human rights recognize that investors have the responsibility to protect human rights. Taken together, these instruments create the implication that legitimate tenure rights holders can be treated as third-party beneficiaries of contracts to which they are not explicit parties. What's really interesting is that there's evolving scholarship that shows that under certain circumstances, third-party beneficiaries have the legal right to enforce the contract or seek remedy in the case the contract is breached, even though they aren't signatories to the contract. So this is an area of law that I think it will be very interesting to watch closely. Final slide, please. So as a final note, I'd like to just take a step back and talk about the importance of consultations in this process of negotiating an investment contract and consultations with local communities and legitimate tenure rights holders. A high quality consultation process can head off many of the contractual disputes and operational disasters that we see agricultural investors becoming embroiled in. And you see on the PowerPoint, there's a whole list of qualities of a proper consultative process. I'll only dwell on one, taking into account the power imbalances and information imbalances between the investor and the legal tenure right holder and the local community. I can't overstate how easy it is to underestimate the power of these asymmetries. Local communities may not understand the terms of the deal. They might be experiencing coercion or other pressure from the government or elsewhere that the investor may be unaware of. And often the government grantor of the land is actually aligned with the investor and against the community. And so it's incredibly difficult for community members to voice dissent. The two ways that I have seen that have been most successful in addressing this is first, to move very slowly. Consult and recognize and sensitize 3 times more than you think you need to. Your feedback period, think what's reasonable and triple the time. And second, rely heavily on local intermediaries who have the trust and understanding of the community. That could be a local NGO, a church or a mosque, a school, or some other local institution. Those local partners will be the key to a successful consultation. And with that, I thank the Secretariat and the audience, and I will pass it back to the moderator. Thank you.
Julia, thank you so much for that very clear and comprehensive, while also respecting your time presentation. Thank you so much. Do we have Professor Ken Fack online with us again?
But I said before, I apologize because the connection is not so good from Yaoundé. Mm-hmm. If you hear me, I can continue.
Perfect. On vous entend, and I think if you keep the camera off, hopefully it should work fine. So, vous avez la parole. Merci.
Okay. Je vais mettre la caméra off, comme on dit. Voilà. Alors, the UNIDROIT Secretary for having associated me with this project, and special thanks to 2 persons. Madame Frédérique Metz, si vous êtes en ligne, merci beaucoup pour votre aide. Et surtout Neil Bergam. Thank you, Neil, if you are online. You helped me a lot to be part of this process. I propose to focus my intervention on 2 critical aspects of an agricultural investment.
Okay, so unfortunately, due to connection issues, as the professor mentioned, the connection is not terrific down there. So what we'll do is we'll invite our next speaker to take the floor. Professor Lorenzo Cottura is at the International Institute for Environment and Development, IIED, as well as having an appointment at the University of Strathclyde. So Lorenzo, are you online?
I am, yes. Carlo, can you see me? Can you hear me?
Yes, we can. Thank you, Lorenzo. The floor is yours. Thank you.
Thank you so much, Carlo, and thank you all for inviting me to be part of this a celebration or moment of celebration. It's been a real pleasure for me to collaborate with UNIDROIT, with IFAD, and also with FAO, and also with all other members of the working group on this project. I wanted to make a few comments about the guide itself and what really attracted me to the project, and then maybe a few points more specifically on the content or parts of the content of the guide. And on that, also on the first point, I think the global surge in large-scale agribusiness plantation deals that happened a few years ago, particularly in low and middle-income countries, really highlighted the problems that are often associated with large-scale investments in agriculture. And I think the fact that there are international instruments, including the voluntary guidelines on tenure that have been mentioned earlier, that provide guidance on how to ensure respect for legitimate tenure rights, and also that provide guidance on how choices should be made about how competing visions of rural development can be reconciled. I think that guidance provides an opportunity to reflect on how to harness it in order to promote real change, translate the guidance into actual change. And for lawyers, there are many different entry points that are possible, of course. In an investment context, I find that the contract entry is particularly helpful. It's helpful because it enables us to look at the real deal, so to speak, as opposed to, say, social philanthropy on the fringes. Now, the guide recognizes that issues are best addressed through national legislation, because national legislation sets a level playing field applicable to all. But the contract itself can also play a very important role, not only in implementing national law, but also where necessary to fill gaps. For example, if national law falls short of international standards. And the aim I saw in the project is not only to improve contractual practices for a particular type of investments, but also, and possibly even more importantly, to remove the hidden subsidies that often favor irresponsible investments. For example, where the land is made available to investors for free or at low cost, or where it's allocated over the heads of the people who claim it as theirs. So I think the guide is helpful in that respect, in that it looks not just at the content of the contracts, but at contracting as a process through which the contract is developed and established. And I think the presentation from Julia just now outlined some of the ways in which the guide does that, particularly in translating, outlining the implications of the notion of legitimate tenure rights, which is a notion that is reflected in the voluntary guidelines on tenure. And what that means for the ability of holders of legitimate tenure rights to make informed choices about proposed investments. So the issue of quality in consultation processes, ways to address power imbalances between different parties, access to technical support, etc., are all very important aspects that in fact are in many ways neglected, including in some of the instruments that exist out there that are seen as best practice. So we think that the guide provides a useful contribution there. But the aspect I wanted to focus on as regards the content of the guide is about the rights and obligations of the parties. And I think this topic is important because in that wave of investments, there was a recurring perception that many of the deals were one-sided. That one party had a lot of the benefits and the other party had a lot of the costs. And so the guide devotes substantial space to discussing ways to frame the rights and obligations of the parties and elaborates extensively, in particular, on investor obligations. Now, this includes a diversity of areas. To illustrate, there are monetary obligations or obligations in monetary matters with regards to taxation, land fees or land rental fees. And there the guide elaborates on some of the considerations that arise when looking at different types of revenue models. Another example of theme where the guide explores investor obligations is the area of employment creation, access to jobs, and labor rights. And of course, for this type of investments, jobs is often the main benefit that investors highlight. And so how to translate promises into actual commitments that are enforceable is an important question, including an important contractual question. And the sort of issues that the guide examines there are in many ways recurring issues with regards to employment and labor relations, particularly in large-scale investments. But the guide also explores some issues that are specific to the agricultural sector in some depth. So for example, issues of gender equality and occupational segregation in agriculture, whereby women very often feature more prominently than men in low-paid casual jobs, whereas men are more often in managerial roles, and ways to address those sort of issues. A further area of obligation that we have been exploring in the guide is the issue of performance requirement, which is itself a huge topic, but essentially measures that contracts, among other legal instruments, can put in place to maximize the linkages between the investment and the local economy, for example, by favoring sourcing inputs from local suppliers. Additional themes relate to community development funds and social infrastructure, so ways for some of the benefits that the investment generates to actually stay in the communities that are most directly affected by the investment. And of course, the area of environmental protection, from impact assessment processes throughout the contracting, as part of the contracting procedures, all the way to the actual substantive provisions of the contracts and the way in which the contract can help manage environmental issues associated with investments. Now, I would say that in relation to these areas, we've followed an approach that characterized by a few features that perhaps we can share here as well, particularly when it comes to content issues, and particularly when it comes to discussing the rights and obligations of the parties in a contractual relations. It's very difficult to be prescriptive. It's difficult to be prescriptive because contexts are incredibly different. The types of investments, the actual terms of the deal are very different. The model of the investment are different. And so it's impossible in many areas to provide a definitive prescriptive orientation through a guide that aspires to be relevant to very different contextual situations. So what the guide does, for example, when discussing issues such as revenue provisions or performance requirements or other, is that it outlines and spells out some of the considerations that will need to be considered in making informed choices about the sort of approach that the parties want to choose and prioritize. So that's an approach that cuts across the various areas of obligations I mentioned. Another comment about the underlying approach is that while the guide is inherently grounded in legal doctrinal issues, it is also attentive, or aspires to be attentive, to a consideration of the real life issues that are involved in this type of investment. So I think through the working group, we've been reflecting not just on the complex legal issues at play, but also the sort of issues that arise in real life in this type of investments, and ways in which the contracts can provide responses, at least partial responses, to those problems. And then finally, the final note I would make on the approach is that the audience of the guide is an audience of lawyers, but lawyers can play very different roles when it comes to large-scale investments. They can act as counsel for companies, they can advise governments, they can also advise legitimate tenure rights holders and local groups. And so the guide aspires to provide support to all those different types of legal professionals. And so, of course, when then discussing issues such as the rights and obligations of the parties, the framing of the guidance was deliberately pitched in a way that it can work for those diverse types of audiences, which is in many ways a challenge, but also has been, I think, a very rewarding process in terms of thinking through the issues from different perspectives, the different interests that may be at play in the investment. So that's the few thoughts I was going to share from my experience of having been involved with this process. But yeah, I very much look forward to the discussion with the other speakers and the participants, the audience. Thank you.
Lorenzo, thank you very much for that very clear presentation. And we will now proceed to our next speaker. We have with us Miss Bénédicte Fauvarque-Cosson. She's a judge at the Conseil d'État en France, as well as a member of the UniDroit Governing Council. So I give the floor to Madame Fauvergue-Cosson, Madame la Juge.
Thank you very much. Firstly, perhaps I will tell you what attracted me to this project. And I think it was really, like Lorenzo just said, the idea that this guide could provide practical assistance for lawyers and also for non-governmental organizations and all sorts of organizations. The second reason is that it very much draws from the work that has been done previously by UniDroit, particularly the UniDroit principles on international commercial contracts, and also the guide on legal farming. So the chapter 5 deals with the parties to long-term and complex contracts, and it deals with the situations where they do not perform or do not satisfactorily perform their obligations. And it's very important to take this into consideration, although of course national laws have provisions for this, because in the contract, the parties can fix their own rules, provided they do not derogate to the mandatory national applicable rules. So the parties to these contracts, which are very often long-term and complex contracts, as well actually as other affected stakeholders, will certainly have to face situations in which the rights and obligations, and this is chapter 4, which have been contemplated, are not performed or will not be satisfactorily performed for various reasons. These reasons can be events external to the parties' control, or they can be breach of contract by one of the parties. The guide gives guidance on how to deal with cases of non-performance, and it enables the parties to establish a clear contingency plan by including contractual mechanisms that can be put to effective use. Parties are advised to anticipate the possible non-performance events and to provide for corresponding actions. In so doing, parties should of course consider the wide range of remedies an aggrieved party may exercise upon a non-performance event under the applicable law of the contract, and also the potential effects of non-performance events on a broad range of stakeholders. So the guide shows all these potential effects, and particularly it shows the potential effects on legitimate tenure right holders. This chapter focuses first on contractual remedies, and it examines excuses for non-performance. These excuses may be force majeure, which is very well known, at least to contract lawyers. It can also be hardship, and this is particularly interesting in times of COVID. And we know that UniDroit has also a new instrument on these situations in times of COVID, which complements the UniDroit principles. The chapter also provides an overview of remedies and addresses situations in which each of the parties to the contract is in breach. It describes all the remedies which may be available to other stakeholders. It addresses all sorts of situations in which legitimate tenure right holders or local communities are parties to the contract or parties to a related agreement, and deals more generally with third-party beneficiaries. Generally, as I said, the chapter draws a lot of inspiration from the UniDroit principles. Just as in the UPIC, UniDroit Principles on International Commercial Contracts, the major principles are those of proportionality of remedies. This means, for instance, that you're not going to terminate the contract for a very minor breach, good faith, fair dealing, cooperation between the parties. All these are key principles for general contract law, and they are key principles in this guide too. In fact, they are especially relevant for long-term contracts. Suffice it to mention here the provisions on hardship or force majeure. As our Secretary General and also as Anna Veneziano said before, there is a lot of private law particularly in this chapter. Finally, this chapter also incites the parties before resorting to court or resorting to arbitration, if there is an arbitration clause in the contract, to resort to amicable forms of resolution, negotiations, mediation. And in this respect, it is very important, and these are provisions that have not been included in the UNIDROIT principles because the UNIDROIT principles do not deal with this aspect. For this reason also, I very much invite you to go and have a look at chapter 5.
Merci beaucoup, Bénédicte. Thank you so much for that. And I'd like to now ask our next speaker. This is Professor Virgilio de los Reyes from La Salle University in the Philippines. Professor de los Reyes, are you there?
Yes, can you hear me well?
Absolutely, the floor is yours. Thank you so much.
Thank you very much. I have been given the chapters on what happens when things go wrong. And these are the chapter on transfer rights and the return of tenure rights in the agricultural land investments. And as I said, this is a chapter which any contracting party would not want to happen. And usually when two contracting parties enter into a contract, they would think that they would be in that relationship for a long time. And this chapter in the guide covers the situations when transfers occur. And these come in various terms, in terms of assignment, acquisition, or cession. These assignments may very well be total, where the investor assigns all their obligations to another party who was not originally a party to the contract. Or they could be partial assignments by the parties. And these partial assignments of obligations and rights can occur in terms of fulfillment of undertakings or even in terms of payments. The third most sophisticated form of assignment, which the guide covers, is the case where an investor assigns to another, becomes another entity because the shareholders would have changed. And this is when the ownership of the juridical entity itself changes. So what would be the general considerations put in the guide? I think the first major general consideration, which is seen in all parts of the guide, is the fact that there is an overlap of legal sources of rights and obligations. Land is a very sensitive issue wherever you go in the world. It is a Gordian knot of laws. Unlike other private arrangements, land is a very sensitive issue. And because this guide covers the two parties, primarily the relationship between the two parties, between an investor and the grantor, then all the more the guide in almost all its chapters gives this caveat of the overlap of legal sources. Because of the sensitivity of land, the limitations of transfers of the rights over land is the subject of nationality, equity, and capability issues, which must all be considered by the contracting parties at the onset. This particular chapter, like I said, talks about the situation, what happens when things go wrong. But not only are the two parties involved, there are usually and normally and most probably parallel agreements with legitimate tenure rights holders, a topic which Professor Lorenzo Cotula covered very well. Now, the legitimate tenure rights holders, it does not end there. There are local communities. So there is consent of parallel rights holders. Now, if assignment of rights are complicated enough in a contract between two private parties, the parallel rights holders, which are the legitimate tenure rights holders and local communities, makes assignments in these land investment contracts even more complicated. The consent to be secured from the parallel parties in processing of the securing of the consent at the onset or the inception of the contract, must consider what would happen in case there is an assignment. How do you now get the consent of the parallel parties? In the case of a transfer of ownership of shares in the investor, in the juridical entity of the investor, unlike parties, private parties to a contract, there may be more restrictions on transfers which do not require consent. What would not require consent, which would require consent of the grantor itself, or sometimes even the parallel rights holders. What would be the threshold of consent? What would happen in case of mergers or joint ventures with other entities? Now, the guide does not seek to plug all holes, but what it does is to raise the flag and give warnings. And I think the basic warning in this particular section is a transparency between the parties. It is a running thread in the entire contract. It is a running thread in the entire legal guide. And this is something that cannot be emphasized enough. The second part that I'm assigned to give you an overview of is the case of returns. Normally, parties that enter into a contract would expect that they would run the full term of the contract. But the question now is, what happens if there is a premature disengagement? What happens to the subject matter of this particular contract? What happens to the assets and the land and the other considerations in the contract in the case of a termination? There are some general considerations that we need to look at. One is that the assets that are involved in a land investment contract are not just land. There would be movables. Normally, in a situation of a large-scale investment contract in agriculture, there would be buildings, there would be processing and manufacturing equipment. There will even be technology and intellectual property rights and processes. There will be immovables. And the immovables, especially in a situation where the grantor is the government and the investor is a private party, to entice the private party investor to invest in a particular parcel, the government may be putting up infrastructure, or the reverse may also happen. The investor may put up infrastructure. Now, what happens in case of a pre-termination or in the case of termination? Who receives the assets? The grantor could very well be a national government or a government on the local level. In a federal state or a unitary state, there would be several levels of land ownership by the grantor. Will it be the legitimate tenure rights holders, the community or third parties of the contract? These are considerations which the legal guide raises. These are the items that the parties and the parallel parties must consider in drafting the particular contract. And in the case of a pre-termination, who pays for these assets? Will they be removed? What kind of serviceable status do we need to look at? What can be removed by the investor? Of course, if you put up a bridge or a road, that will be very hard to remove, but what about the buildings and the factories and the other processing equipment? A big issue in all of these contracts is the deterioration of assets or the restoration of trees, vegetation, or standing crops. In the case of a pre-termination with standing crops, who now owns the standing crops? What about the other physical characteristics of that has been changed in the land or altered in the land because of the original contract between grantor and investor? And what would be the time periods for fulfillment of obligations? Now, in a termination clause where there is a fixed period and the contract runs its life, then the parties will still need to provide for the periods of fulfillment of obligations. The same thing will occur in the case of a pre-termination. So, Chapter 6, as Professor Ignacio said, in the early part of this particular work, there was a lot of discussion within the working group of, do we even tackle this issue of grantor and investor, where the investor leases land from the grantor? As Professor Ignacio says, it happens in real life. We either ignore it or we give a guide to both parties in entering into this contract. The UNIDROIT, the IFAD, and the FAO began in 2015 with the legal guide on contract farming. This is the second legal guide that has something to do with agriculture. The value of these two guides will be even better, will even be bigger when the UNIDROIT enters, and these three groups of UNIDROIT, IFAD, and FAO enters into the third component of the relationships in agriculture. And I'm talking about the legal structure of agricultural enterprises. If you look at the first guide in 2015, which talked about contract farming, and now on land, and I hope the third will come on the legal structure of agricultural enterprises, we would have had a marriage of the approach from the public law and from private law, which I think is a big gap that is very valuable, not only for the investors, but more importantly, for the producers of our food in this era of climate change. Thank you very much.
Thank you very much, Professor De Los Reyes. We will now proceed to the next portion of this section of this panel, the section of the launch event, where we're going to ask two observers to the working group's work, as well as two people who have provided, experts who have provided us input throughout the process, including during the consultations. The first speaker will be Ms. Sarah Bruin. She's a senior law advisor and coordinator with the Advisory Services of the Economic Law and Policy Program with the International Institute for Sustainable Development, IISD. So Sarah, the floor is yours. Thank you.
Thank you very much. I hope you can hear me well. Good afternoon. Please. Thank you. Good afternoon to everyone, and thank you so much for inviting me to speak today at the launch of this incredibly valuable guide. I'm going to take a few moments now to share some brief thoughts on what the practical implications of this guide might be, both for governments and for private investors. And to begin on the side of governments, and especially governments in low and middle income settings. Like a number of the expert authors of this guide, I've spent a lot of my career working with and advising developing country governments on legal and policy frameworks for responsible investment in agriculture. I've worked as an embedded legal advisor for the governments of Samoa and Rwanda. And through these experiences, I've really seen firsthand the need amongst government officials in countries like this for legal guidance like that offered by this guide. Guidance that is thorough and comprehensive, but also clearly expressed, practically grounded, and firmly embedded in international principles. And so I really do hope that this guide finds its way into the hands of agricultural investment negotiators, state lawyers, parliamentarians, and policymakers who I know will make great use of it. And in particular, I think the guide will be incredibly useful for governments in translating the principles of instruments embodying international consensus, like the CFS-RAI, the VGGT, the UN Guiding Principles on Business and Human Rights, not only into the provisions of their land-based investment contracts, but also the manner in which those contracts are designed, negotiated, implemented, and monitored. While the guide is titled A Legal Guide on Agricultural Land Investment Contracts, I really think that its guidance could be equally applied in many cases to laws, policies, and regulations governing investment in agricultural land. And for this reason, I think that the guide is going to have a really important role to play, not only in shaping the development of contracts, but in the creation of a broader legal framework. And we can't forget that the strongest foundation for more responsible and sustainable investment in agricultural land is the ongoing development and enforcement of a domestic legal framework. It's the strong foundation of domestic laws, policies, and regulations governing all areas of investment in land, whether it's related to tax, labor, water, environmental protection. This is really the best guarantee for positive outcomes and for consistent, coherent, and transparent rule of law and governance. But as the guide rightly acknowledges, these contracts continue to be an important and a widely used source of law in many low and middle income countries. So I hope that governments will take this guide and use it not only in the context of individual contract negotiations, but also to develop flexible templates and model contracts that can be used to help ensure that their contracts are being used generally in a way that's more consistent, more systematic. I believe a model contract developed in a consultative and transparent way, tailored to a country's legal system and outside of the pressures of an active negotiation where an investor is knocking at the door, can help to support better negotiation outcomes and a more coherent role of contracts within the wider legal framework. So that's the role I see for this guide on the government side. Before I finish, I'd like to comment briefly on the role of the guide in trying to attract more responsible and more sustainable private sector investment in agriculture that we all know is so critical. And in this regard, I think it's relevant to mention the Zero Hunger Private Sector Pledge, which launched ahead of the UN Food Systems Summit on Tuesday, and as part of which 42 companies pledged to invest $345 million to contribute to ending global hunger in 34 priority countries, mostly in Africa. Pledging companies ranged from large corporations to SMEs, and each of them made financial commitments in at least one of the 10 high impact intervention areas identified in the Ceres 2030 report. And critically, each company pledged not only financial commitments, but they also committed to upholding internationally accepted principles like the CFS-RAI and the UN Guiding Principle for Business and Human Rights. So what does all of this have to do with the ALEC Guide? I think that this interest in the private sector pledge from companies shows that those companies are starting to expand their conceptions of corporate social responsibility, and to see that meaningful contributions to ending hunger needs to be mainstreamed through their core business operations, not be an act of charity, because this is what makes business sense. So I really see that this guide has a significant role to play in informing and influencing how those companies engage with governments and communities for the negotiation of contracts for land. The guide is also being expressly designed to elaborate on and to operationalize principles of international consensus reflected in things like the CFS-RAI. These are two instruments, the CFS-RAI and the UN Guiding Principles, both of which are instruments that pledging companies have committed to abiding by. And so I really see the guide as serving as a roadmap to those investors to ensure that their compliance with these high-level principles in the process of meeting their contractual obligations over land that is leased to them for their investment operations. So in closing, I really want to commend UNIDROIT, IFAD, and all of the experts and members of the working group that have brought this guide to fruition. The process of the guide's development was one that I had the privilege of being involved in as a working group observer, and I can really attest to the rigorous, thorough, and collegiate process that went into making this guide the high quality, highly relevant product that it is, and one that I know will be of immense value to governments, private sectors, private investors, and beyond. So thank you all very much.
Sarah, thank you very much for your comments and your intervention. Very appreciated. I would now like to turn to our next speaker, Dr. Titilayo Adebola. She is a lecturer in law at the University of Aberdeen, and I had the great fortune of meeting her in person as she was one of our panelists at the regional consultation event held in Nairobi in October 2019. So Titi, please, you have the floor. Over to you. Thank you so much.
Thank you very much, Kalu, and good day, everyone. Warm greetings from the University of Aberdeen. I heartily congratulate the International Institute for the Unification of Private Law, UNIDROIT, and the International Fund for Agricultural Development, IFAD, on the joint publication and launch of the UNIDROIT-IFAD Legal Guide on Agricultural Land Investment Contracts. I'd like to thank the organizers for the invitation to reflect on my participation during the consultation process. I was involved in 3 ways. First, by helping to organize and contribute an essay in the Afronomicslaw.org online symposium. Second, by participating in the African Regional Consultation. And third, by submitting recommendations to the online public consultation. I will outline each of these interventions in turn. Afronomicslaw.org hosted a successful online symposium convened by Professor James Tolgati on the UNIDROIT FAO-IFAD Legal Guide on Agricultural Land Investment Contracts from 29th September 2019 to 12th October 2019. The symposium presented brilliant contributions from 9 experts, including myself. We had contributions from Professor Michael Fakhri, the current United Nations Special Rapporteur on the Right to Food, Tommaso Ferrando, Chidi Ogwuamanam, Nicolas Perron, Sam Zook-Berg, Philip Sweat, Sarah Sek, and Adebayo Majekolagbe. We covered topics ranging from human rights, foreign investments, climate change, environmental impacts, land deals, to intellectual property rights. While experts discussed other complexities of agricultural land investment contracts, I dedicated my contribution in the symposium to access to food and intellectual property rights. On access to food, I underscored the importance of ensuring that human rights impact assessments on the right to food ensure that investments cater to the production of domestic staple food crops to serve local markets and improve local food sovereignty and food security. In other words, the production of crops should respond to local needs. I further emphasized that the guide should provide a firm structure for the distribution of food products by prioritizing domestic consumption demands over export market demands. On intellectual property rights, I highlighted the need to include potential impacts of intellectual property rights on investments, as the existence of IPRs for seeds and plant varieties, such as patents and plant breeders' rights, play a significant role in attracting investments, but may limit small-scale farmers and farming community rights. I'll turn to the second intervention through the African Regional Consultations. I was invited to contribute to the 3rd Regional Consultation Workshop, which focused on Africa, and it was held in Kenya at the Strathmore Law School in Nairobi on the 23rd of October 2019. The thought-provoking African Regional Consultation brought together stakeholders in Africa, including government officials, intergovernmental organizations, non-governmental organizations, private sector representatives, legal practitioners, and academics. The workshop offered the opportunity to discuss the possible implications of agricultural land investment contracts on rights and obligations of stakeholders and parties in Africa. There, I explicated the positions I preferred above. I submitted my recommendations also during the online public consultation via UNIDROIT's website on 29th of October 2019. Overall, I am pleased that the consultations were undertaken and that some of my recommendations were adopted and incorporated in Chapter 3 of the final ALIC guide as set out next. In 3.44, under a holistic, integrated, and participatory approach to impact assessment, it was included the inclusion of intellectual property rights. So that's on pages 62 and 212 on the impact assessments. On 3.62, access to foods, we had the inclusion of farmers' rights, especially smallholder farmers' interests, and that's on pages 69 to 70. On 3.63, the right to food impact assessment, we included the prioritization of domestic needs, and that's on page 70. And finally, on 3.64, impact of intellectual property rights, we included the consideration of the impacts of intellectual property rights, such as patents and plant breeders' rights on land, farmers, local communities, technologies, innovation systems, and practices, and that's on page 70. Once again, I'd like to congratulate UNIDROIT and IFAD and FAO for this brilliant guide, and I wish us all the best in its implementation. Thank you.
Didi, thank you so much for that, for your intervention, and as well as very, I think, very usefully and very eloquently describing the process, concretely the process of consultations, both the online, you mentioned yours, as well as the other brilliant contributions on the Afronomics online blog, which was a special seminar organized by Professor James Gatti, a member of our working group, of course, as well as the describing concretely how the regional consultation event in Nairobi, how that was organized, and as well as how the feedback from that was incorporated into the guide concretely. So thank you so much for that intervention. I'd just like to quickly note we've received word from Professor Pierre-Etienne Kenfack, and he sends his apologies. Apparently the internet connection simply wasn't stable enough to permit him to speak. He has very kindly shared a written version of his remarks, which I will read quickly here, just because there is some very important key points captured in there, and then that will be it for the speakers, panelists, and we will have the last portion of time allocated to any questions or feedback or interventions, questions and answers. So we'll have the last minutes before we wrap up at 4 o'clock. So I'll quickly read the written remarks from Professor Kenfack, who again sends his apologies about the technical issues he was experiencing. So his intervention focuses on two critical aspects of agricultural land investment contracts, and he organized it in two questions. So the first question is, who are the contracting parties to an ALIC, to an agricultural land investment contract? And the second question, key question, is, well, who are the stakeholders in the contracting process? So essentially, in the case of an ALIC, there is a very important distinction which is traced in the guide, very, very clearly described. And that distinction has a through, there's a through line throughout the guide where this crucial distinction reoccurs, which is the importance of why Professor Kenfack was raising, was structuring his intervention around this. So the distinction, the first distinction is that there is, on one hand, there's the notion of legitimate tenure rights holders, and that is essentially to say that those people who may not have a legal status or a sort of traditionally in the sense of a written recognized legal status, they may nonetheless be parties who have legitimate rights and in the land and who need to be included in the consultation process as well as in the contracting process. So this is a key point that he sought to highlight. And in this case, the identification of each of these stakeholders is fundamental if the investors wish to avoid the risk of that while legally valid by the strictest interpretation of the written contract, may in fact turn out to be very difficult to enforce, as it could invite all manner of claims brought by the legitimate tenure rights holders. So this is a really crucial distinction, which is traced in, which is made in the guide, and which crops up throughout the various chapters that were described by my colleague Priscilla, as well as by a number of our experts and speakers today. So essentially, legitimate tenure rights holders, These may be individuals or communities who occupy and use land without the need for a title to that land. So they consider themselves to be the holders of rights to that land, and their claims are considered to be socially legitimate by local societies and several international legal instruments. So this was one of the first key point that was included in Professor Kenfak's notes. And again, he indicates here in his notes that there are a number of international instruments such as the ILO Convention number 169 on the rights of indigenous and tribal peoples, as well as other international instruments which emphasize the importance of recognizing legitimate land tenure holders. So the ALEC Legal Guide highlights the need to include all of the potentially affected stakeholders throughout the contractual process. And where there is confusion between legal and legitimate rights holders, where there is such confusion, the contractual negotiations should seek to involve the investor and all types of tenure right holders and legal rights holders in order to avoid risking future problems and legal and other kinds of challenges to the contract. The second very important point that Professor Kenfak draws in his intervention is around the identification and of the stakeholders, all of the various stakeholders who are important in the ALEC contracting process. And these include, of course, relevant third parties to the contract. So in the guide, it is indicated that a third party beneficiary in a contract is a person, entity, or community with an interest or concern that may be directly or indirectly affected by the implementation of the contract. The guide reminds us that identifying all of these third-party beneficiaries and stakeholders and their respective roles from the beginning of the contractual process is an essential condition for the implementation of responsible investment in agriculture. And given that the identification of all of the relevant stakeholders and third-party beneficiaries is not always an easy matter, the guide has mapped out a number of the most common a number of the most common stakeholders involved in these kinds of contracts, as well as a number of methods by which that they can be effectively mapped out and appropriately and properly consulted. So the guide invites investors to ask themselves a number of key questions, including one, whether all stakeholders with an interest in the land and resources have been clearly identified. Two, whether their interests have been clearly identified. And lastly, whether all parties with legal and/or legitimate rights have been identified. So this is merely a quick overview of a few of the key issues which are at stake in the guide. And of course, it is our fervent hope that they will serve as a compass for more and better responsible investment laws and investments relating to agricultural land. So that is the notes from Professor Kenfak's intervention. And again, he apologizes for the technical difficulties. Having wrapped up our interventions from our experts and working party experts and observers and experts who participated in the consultation process, we now have just a little bit of time left over if anybody would like to either online or here in Rome in the library here in the Sala Rodino. If anybody would like to take the floor to either questions or comments or feedback, the floor is now open for a Q&A session. Thank you so much. So again, the floor is open, and I believe we have a Professor Veriziano. The floor is yours.
Thank you very much. Just one comment. I think there are plans of translating this guide in different languages. So maybe this could be interesting for everyone to know what are the languages in which the legal guide will be available. Thank you very much.
Thank you so much, Professor Veneziano. Priscilla, I don't know if you would like to address that point. You can give further information, and I'll pass it to you, and then I note that we also have a comment online on the comment box. So please, Priscilla, over to you.
Thank you, Carlo. Concerning the translation, I believe we are in the process of doing the translation into French, as we did with the legal guide on contract farming. And I believe in our concluding remarks, we will also share other activities that we are planning to do for the implementation of the guide. That being said, we do have one question in the chat box. Carlo, if you would like to read it. Thank you.
Thank you, Priscilla. So we have a question coming to us from Ms. Federica Violi. Her intervention, or her written intervention, reads as follows. Thank you very much for the tremendous work in drafting the guide. I had the pleasure of submitting my comments for the online consultation round. I have a question related to legitimate tenure rights holders. How to approach disagreement/conflict among legitimate tenure right holders who enjoy overlapping claims over the same land. Thank you. This is from Federica Violi. So that's a question that, of course, any of our experts from the working group or observers, if they'd like to say a word about that, the floor is open.
I can just start with saying a word about this. Thank you for the question. And this is indeed a situation that is encountered not infrequently. I would say that certainly those types of disagreements and conflicts, if at all possible, would need to be ironed out before the actual contracting happens and before the investment contract is entered into, because those become sort of ticking time bombs that can derail the investment once it's in process. The best way that I have seen to surface this, and it's not easy, is in the pre-negotiation due diligence and stakeholder mapping that the investor is conducting. The ALEC guide has a section on stakeholder mapping, and part of that mapping involves mapping not just who are the stakeholders, but what are their rights, and surfacing those types of disagreements and ensuring as part of the due diligence process that those are resolved before the contract negotiation proceeds. I don't know if any of the other contributors have anything else to add. Thank you for the question.
Thank you very much, Julia. That was indeed quite an important distinction, and that's very clear. The floor is open for other questions or indeed other experts who would like to follow up on that. Yes, Professor De Los Reyes, please, the floor is yours.
I think the one thing we need to remember is that the legal guide covers the contract between the grantor and the investor, and the grantor here is the government. What the contribution of the guide to this process of conflicts between legitimate tenure rights holders is, I think, the principle of transparency. It forces the parties to be able to include all the stakeholders in the community, even local communities who may not have title in the classic sense of land ownership. And as Julia said, they need to be involved. I mean, the information asymmetry between local communities and investors in relation to government is very great. And I think that's the one unique contribution of this legal guide, is that it forces the parties to consider those that they would not usually have considered, or of course in some really egregious cases they choose to ignore. Thank you.
Thank you very much, Professor De Los Reyes. Again, we've got just a little bit of time left if there are anybody else would like to take the floor with any observations or comments or questions. I recognize Governing Council member, Professor Da Coronha. Please, the floor is yours.
Thank you very much. Just as a member of the Governing Council, I would like to express my thanks for all this wonderful work done and to congratulate all the persons that have contributed to this. The excellent work done by the Secretariat and also by the IFAD. And not only to express this thanks for this book, but also for the guide on best practices for electronic collateral registries that has been launched today in the morning. So thank you very much for all this great work we have done.
Thank you very much for those kind words, Professor Da Coronha. The floor is open. We have just a few more minutes. So if anybody else would like to, either here in Rome or online, if anybody would like to share comments, feedback, questions, the floor is open. Thank you so much. So if we don't have any other additional interventions at this stage, I think I see a Q&A on the online. Can we see that, Priscilla?
We've addressed that. It was
okay.
Federica
Excellent.
Viola.
Okay, thank you so much. So we have a few more minutes, and perhaps we can I can pass the floor over to the Secretary General, if you'd like to make any concluding remarks or
no, thank you. Concluding remarks, our President.
Excellent. Okay. So so that's it. I will thank everyone for online and here in Rome for attending this launch event.
Do you mind if I conclude?
I was just about to pass over to our President. Thank you so much.
Thank you, Carlo. It's just since I think you have appreciated how relevant and important, I would say, relevant and deep this legal guide is on the matter. There is a lot of work that now can be done to implement the legal guide. And the partners had drafted a sort of agenda on at least the proposal to take a number of actions. One of these was, as was already asked by Anna Veneziano, the issue of translation. The legislative guide will be translated into French soon, as it was done with the previous guide. And there is the intention to translate this also in other languages. Spanish and Chinese are taken into consideration, and we hope to be able to start this kind of work as soon as possible. As I was saying yesterday, it is extremely important for all our instruments that they are translated in many languages to widen the understanding and the knowledge, the awareness of what we do. Then, of course, we will do what we normally do with all our products, and that is the presentation of the guide also at key international conferences and venues. That will be the job for all of us, for IFAD and UNIDROIT, and all the other people that were involved in this exercise. One of possible forum where to present it is the Land and Poverty Conference that is held annually at the World Bank. Then, of course, we will keep on with online dissemination and workshops for knowledge transfer. And we are expecting, or we envisage, to have webinars and focusing possibly on specific issues to permit a deeper consideration on chapters or specific rules and issues. And this will go together with the preparation of outreach materials, again, for the guide in general or for specific topics. And what I think is also extremely relevant for this exercise, we are also planning to prepare a comparative study of regulatory frameworks for agricultural land investment. And this is done to be able to identify regulatory trends that might assist to formulate or adapt their own national legislation on the basis of the recommendations that are and the guidance that are contained in the ALIC legal guide. And I think this is a concrete step that goes much further, much beyond the dissemination of the content of the legislative guide. Is a step further. To the same extent, we by the contract template that will fully adhere to the principles and recommendations of the legislative guide might be eventually developed, and that would again be quite a step. To finish up, again, probably I will link this, go back to my circle when I was commenting on the possibility to translate the legal guide into as many languages as possible. We intend also to establish a community of practice formed by the experts involved in the working group and representatives of major stakeholders of the project, whether practitioners, academics, or policymakers. The idea is to have a dialogue between stakeholders, and so it's a way to widening the acknowledgement, the knowledge, and the awareness of the principles in the legal guide, but it is also a way to go further and build up a community of people working and discussing on those topics. These are trends that we try to follow in other instruments of UNIDROIT, and I'm sure that this is a kind of agenda that is fully shared by IFAD, not only in this case, but normally in the way the organization works. So it is a landmark product in my understanding. It is extremely timely. I mean, I shouldn't say so as being one of the partners. I mean, being the organization one of the partners, but I think it is really the right time for this kind of documents, for all the debate that we also have on sustainability and poverty, food at this point of time. And I think it is really time also to implement this instrument and all those instruments linked to this with what we try to do in this agenda. So not only we discuss the content and we hope to keep on discussing it, but we will do further work. And on this, and as it was already announced, also with the same partnership on other products, always addressing the same goals. So I think this is really the best way, in my understanding, to closing not the old works that we had in the past days, and all what was done also in cooperation with other international organizations. So unless there is anyone else who needs to take the floor, I can only enormously thank all people who participated, not only in this exercise, but if you permit me, also in the other guides, and for those at UNIDROIT of the Governing Council that stayed for 2 days discussing a lot of items, the launch of these new products. Thanks a lot for having been here, for those who could reach Rome or follow us on web, for those who followed the whole of the session on the web. So thanks a lot. We are a community and we try to keep building upon that to improve and do our best, I hope. We are tired. It has been a long week, I think, for all of us. Thanks a lot for being here. And I hope to see you very soon, apart from the celebrations of the 100th anniversary of the Governing Council that will continue during the weekend and on Monday. But this is something that will celebrate the Governing Council. So it's not really part of the launch of this instrument. Thanks a lot. Have a nice weekend. And thank you for all the efforts, the cooperation, the solidarity, and the support that you keep giving us. Thank you.